Good afternoon. This matter is entitled Riverside Townhouses versus Lateral Walton. Miss Walton is here. Also, Attorney Carrie Zanin is here from her world headquarters and ready to address this matter. Also note Meg Bauer from Legal Aid is present. Miss Walton, they wish you to move. They filed a termination of tenancy back in July, asking you to leave. And as a tenant in such a case, you have certain rights, which I'm going to tell you about right now. As a defendant in a landlord-tenant proceeding, you have the following legal rights. You have the right to obtain counsel for representation in this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you. And as indicated, Meg Bauer is here with us.
Okay.
You have a right to a trial by a jury or by the court. If the action is for non-payment of rent, we would take a different direction than what we're doing here. This is a termination of tenancy. If the plaintiff is agreeable, the Citizens Mediation Services, Inc. may be available as a possible source of case resolution. If both parties are interested, the court can help set that up. If you do reach an agreement with the plaintiff and a consent judgment is entered by the court, you would waive the rights listed above but have the following additional rights. The judgment could not be enforced until 3 business days had passed. You could move to set aside the judgment within those 3 days if you misunderstood what you consented to or what you were waiving. Your motion to set aside the judgment would be set for a landlord-tenant hearing. However, if the judge did not find in your favor, the original judgment would stand. Now, this is filed as a termination of tenancy. Attorney Carrie Zanin, as I said, is here for the plaintiff, and one of the representatives from Riverside is here, Zach. They filed this notice to quit on you on July 25th. Looking at the addendum, it says you're a material breach for disturbing your neighbor's right to use and enjoy the property. Specifically, you, your occupant or guest, went into another unit and physically assaulted another resident, which necessitated police report. You currently have an assault and battery case pending here in St. Joe County, 23.416 SM, and disturbing the peace, and that's set for a pretrial with Judge Pattison on November 2nd. I'm not sure if that's the underlying event, but
no, it's two different
things.
Yes, those charges that the police report, those charges weren't filed against me because it was false. So
all right, Ms. Zanin, what's your position here?
Judge, my position is that we are seeking possession regarding all the things that were added. I believe that the police report was added to the file, as well as incident reports from other residents as well.
They haven't made it to me yet, so
okay.
Let's take a look, see if they're in the on-base file. Miss Walton,
yes,
the law requires that I adjourn this matter for 7 days. And that would mean we'll continue this to next Monday. But if they get what they ask for, you would be evicted 10 days from next Monday, which would be October the 9th. And you could be barred from other subsidized housing if that eviction was to prevail. I don't think I have all that other information you're referring to.
Okay, Judge.
Let me look.
Would, well, one, I could speak with Miss Walton in a breakout room and see if we can maybe come to a resolution.
All right.
If she would
Ms.
like.
Bauer?
That's, I don't mind.
All right, I'll put you in. I'll put Ms. Bauer from legal aid in there also.
Okay.
Anyway, we'll see where we go, but at minimum, we're gonna adjourn this matter till next Monday, if that works for everybody. But for the time being, I'll put you, now, the incident on that I referred to, file 23416, involves some assaults that were videotaped, and that, according to the affidavit of probable cause, occurred a couple blocks from Riverside. So apparently that's not
A separate
directly connected to this. But Judge Panis is handling that matter, so I don't know that much about it. But all right, I'm going to put you in a breakout room. Let me get it set up here.
Thank you, Judge. Thank you.
And then when you're done, I'll see you all. The other lady I'm going to put in is attorney Meg Bauer from Legal Aid, and she can help and look out for your interests in this hearing. She's not actually appearing on your behalf, but she's there in an advisory capacity.
Okay.
All right.
Thank you.
Some stuff, some attachments to the notice.
Okay.
Attorney Zan and legal aid will not be appearing on this case.
On Lateria Walton.
That's correct, Your Honor.
Okay. Good afternoon, Ms. Zanin.
Good afternoon, Judge. How are you today?
Good. We've got backed up and then we got caught up, and this matter is set for 2:10. It's 2:04, so we'll have to clock tick for a minute.
Sounds good. I heard that Jen was late one time, 7 minutes, and so I will never be late. Always 7 minutes early, Judge.
Okay, very good. And if you're early, sometimes we get a chance to start it. I was just given some.
You know, Judge, I
notice-
apologize for sending that today. I forgot. I know we talked about it last week, and then today came really quickly. So,
All right. Did she get these?
you know, Judge, that's the other thing. I don't know if she did or she didn't. So,
Well, I mean, originally she got these back in July, or when the allegations were?
yes, Judge.
Okay.
And I believe I see Riverside is here. I talked to Lori. I know that I've asked her to come as well today.
Okay. I understand Lori went to a different unit in the company.
She did. We had
All
that
right, let me
conversation. I told her she can't leave me. I said, I don't know what you're doing.
Well, yeah, we do tend to rely on our managers, don't we?
We do, Judge.
I've been talking with the other lawyers. Your firm does a lot of this, talking with Mr. Fleeman and Mr. Sutherland and lawyers that do a lot of landlord tenant about the impending changes, which are supposed to start next Monday. And we have a lot of uncertainty. Legal aid has figured it all out, but the rest of us have a lot of questions. And I'm sure.
I'm sorry, Judge. My concern is where are the new notices?
Yeah, we were discussing that very thing. There are some forms, there are some changes that landlords are supposed to incorporate, and
Hello.
So-
I'm sorry. I could not hear anything.
all right. Is that you, Miss Walton?
Yes.
All right, good afternoon.
Good afternoon.
We return to file 231340, Riverside Townhouses versus Lateria Walton. This was filed as a termination of tenancy action. The complex indicated they wanted Miss Walton to move. Miss Walton wasn't in favor of that idea. We continued the matter until today. Carrie Zanin is here from the Cox Law Firm on behalf of the complex, and the former manager, Lori, is also present. Good afternoon, Lori.
Good afternoon, Judge.
I hope things are much harder for you where you are now, and that you're miserable, and you wish you were still here. So that's my wish for you. Anyway, I'm just kidding, but I got a notice to quit with further addendums, Miss Walton. They allege a number of lease violations. That one of your guests went into someone else's unit and assaulted them. Police came, and they allege a number of other violations, noise, criminal activity.
I never received violations for noise or criminal activity.
Well, let's see here. For the face sheet I got has no date on it. So there's a date of 7/17/23. She stole weed and was confronted by my cousin. They ended up getting into a altercation.
Judge, I think I don't mean to interrupt, Judge, but I believe, and Lori, please correct me if I'm wrong, but I believe all of the violations are stem from this one incident that took place, correct, on July 16th. It's all.
Okay, I thought they meant like different incidents. I was gonna say, I don't have any recollection.
So everything it's all from the July 16th incident.
That's correct, Judge.
I would note that Meg Bowers here from Legal Aid did consult with the defendant last week. Legal Aid will not be filing an appearance in this matter. So, Ms. Walton, they want you to move, and you don't wish to move. You're in the bathroom, I can see, and you got your child with you.
Yes.
What's your position?
Meaning?
Yes.
Like my side of the story, or like exactly what do you?
At this point, you don't wish to move, is that correct?
No, I really don't, because the charges were never filed against me. I spoke to an officer the next day, so.
Well, it doesn't matter whether charges were filed. It matters whether they wish to pursue this. Now, you're entitled to have a hearing on this where I would take testimony under oath from people. But if you're evicted from here, it's going to make you ineligible for other subsidized housing options. And that's a risky thing. If you get evicted after the hearing, you won't be able to get in anywhere else. They may be agreeable to some sort of voluntary move out where you would agree to move out by a certain date and they would dismiss the case, what would be called a conditional order of dismissal. But you have a right to have a trial where they would call the police and these witnesses who, now you have some other cases here, November 2nd, on some stuff down the street, but wasn't at your apartment. So are you willing to discuss that you would move out by a certain date, or do you wish to have your hearing?
Yeah, I wish to have a hearing because she already talked to me about it.
All right, so you don't wish to move?
No.
All right, let me find a block of time, which is hard to do, to set this for testimony. Ms. Walton, it will be live. It will not be by Zoom.
Okay,
Under the new rules, anything with testimony is supposed to be live. It's deer season, but that doesn't affect me.
It doesn't affect me either. I mean, I know
All right,
it's
well, so
confusing. the
how
way
are
I'm
you
looking at it.
for Wednesday, November 15th at 1:30?
that works.
For November?
The only person I need to add, Judge, Lori, do you think you can make that work?
Yes.
Thank you.
All right, and any other witnesses you may need? It will be live. All right, they've discussed a move out with a conditional dismissal. Defendant is not interested. This letter I got, Ms. Zanin, it has no date on it. Dear tenant, you are in material compliance with the terms of your lease.
Actually,
Was that?
that went out with the 30-day notice to quit, Judge.
Okay. All right, so they list a number of things that they allege that you did, plus these reports of resident dispute. So they can bring witnesses to testify to those things. We'll have a trial at 1:30 on November 15th. Is that date work for you,
Yeah.
Ms. Walton?
Yes, it
All
does.
right. And it'll be live here at the courthouse. Okay, we'll address this further at that time. Now, if they get what they ask for and that they prevail in that hearing, you would have until November 25th to move out, or you would be subject to being evicted. I guess if they don't prevail, then your tenancy would continue. But at this point, we're going to take testimony under oath regarding their desire for you to move. All right, that date will work, and I will see you then.
Thank you, Judge. Have a good day.
All right, thank you.
Thank you, Judge.
Let's go on the record. We are here for a landlord-tenant termination of tenancy hearing. Title of the matter is Riverside Townhouses versus Lateria Walton. Ms. Walton is here, albeit she's about 35 minutes late, but better late than not at all. Attorney Carrie Zenin is here from the Aaron Cox Law Firm. Lori Cousineau, the manager at that time of Riverside Townhouses, is present. We also had Officer Nathan Hewitt here on overtime in the Zoom connection, waiting for the defendant. Also, Attorney Ross Truckee was here, who represents the defendant in some other matters, and I greatly appreciate his sticking around to assist with this matter. Ms. Walton, as you recall, quite some time ago, your apartment complex filed a motion to terminate your tenancy. They wanted you to move. You didn't move, and they filed this action to ask me to terminate your tenancy and take possession of the premises. We were here first on October 23rd, and then we were here again on October 30th. Meg Bauer from Legal Aid was available for consultation at each of those hearings, but did not file an appearance. You had indicated at our last hearing on October 30th that you wish to have a trial on this matter. And so I set it for trial today. So everyone is here live, theoretically, to try this termination of tenancy. I told you on June 23rd, and again on June 30th, that if you're evicted from Riverside townhouses, it will most likely make you ineligible to find housing in any other subsidized housing. So there were several efforts that attempted resolving the case with what's called a conditional order of dismissal. Mr. Truckee stuck around today, and it's my understanding he's going to appear for limited purposes in this case only today. Is that correct, Mr. Truckee?
That's correct. I'd appear strictly for the entry of a conditional dismissal agreement on the record today in this matter.
Go ahead and put your name on the record.
It's Attorney Ross L. Truckee for Lateria Wall.
All right, Ms. Wall, did you hear everything I've said so far?
Yes,
Ms. Zanin, are you in agreement with everything I've said so far?
I am, Judge.
All right, so even today, when Ms. Zanin got here, she drove all the way from Warren to be here for this hearing, said we would still do a conditional order of dismissal, so she wouldn't be prohibited from finding other housing. And you guys just met, and I have this proposed consent order for conditional dismissal. And it says rent is zero, court costs are zero, other money is zero because this is a termination. Further conditions, the defendant will vacate and turn in the keys to management by December 15th, 2023, which is 30 days from today. If they had gotten what they asked for today, you would have had 10 days to move out. If there are any new lease violations or police activity, plaintiff can submit affidavit,
Judgment and writ.
a judgment and writ for immediate entry of the court. And if you fail to vacate by December 15th, they can ask for immediate order of eviction. Do you understand?
Yes.
All right, and is that your signature on there? And Mr. Truckee, you discussed this with Ms. Walton as well,
Yes, I did, Your Honor.
and you signed this document as well.
In the wrong spot, but I signed it.
Well, better there than not at all. And Ms. Zanin, you agree as well?
I do, Judge.
All right. Fortunately, we were able to get a relatively quick trial date from October. This is a jury trial day, but because it's opening day of deer season, some people aren't here and no, anyway, we had availability to do it. So, all right, you've got till the 30th or the 15th of December to move. Have you made any effort to find a place to go? All right, now when you move, you need to turn in your keys and give your forwarding address in writing within 4 days of your moving. That triggers the security deposit law. And so that is a consideration. Now, I told you before that if you did enter into a consent judgment, that the rules were a little bit different. And it probably, I read this to everybody and their eyes just glaze over. Supreme Court says we have to read these instructions to everybody. Now they're even more complicated than they were. But let me repeat what I told you back on October 23rd. If you do reach an agreement and a consent judgment is entered by the court, which you just did, the judgment may not be enforced until 3 business days had passed. You could move to set aside the judgment within those 3 days if you misunderstood what you consented to or what you were waiving. Your motion to set aside the judgment would be set for a landlord-tenant hearing, but if the judge did not find in your favor, the original judgment would stand. You understand? All right. Conditional order of dismissal. Entered. writ date 12/15/23. Now, you have a trial set for December 13th on an incident that allegedly occurred last February. And Mr. Truckee is your lawyer in that case. It charges two counts of assault and battery and disturbing the peace. That trial is in front of Judge Pattison. In preparing for this case yesterday, I looked at that case and discovered that the prosecutor has issued a felony warrant for your arrest in file number 232155, which is the incident of July 16th, which is, I think, the same incident that underlies this request. And I don't know why they went from July 16th to November 9th before they filed the complaint. I don't believe it had anything to do with this case. I don't think there was any discussion. I think it had to do with the other case, the one that's set for trial in December. But in that case, it is alleged that on or about July 16th, you did enter a apartment at Javier Drive and commit an assault upon Cachet Nichols. They've charged that as home invasion in the second degree. It's punishable by up to 15 years imprisonment and a fine of up to $3,000. Count 2 alleges you made an assault and battery upon Cachet Nichols. They issued that warrant by Assistant Prosecutor Casey Johnson. Officer Hewitt signed it, and the court issued the warrant with no bond. So you're gonna go to jail right now, and you're gonna get fingerprinted and mugshotted, and I'll see if I can get the magistrate to arraign you before 5 o'clock. So they can set a bond. You're not a flight risk, but there'll be some bond conditions. And so you're gonna be taken out to the jail. I'll see if the magistrate can see you within the next hour or so. Are you her ride over here? Have you got her kids? All right, I don't know. You might as well go back to Three Rivers. And this is probably gonna take a while, but it should be accomplished before 5 o'clock. We'll appoint a lawyer for you and set it for further proceedings. Mr. Truckee's already on top of this, and we'll see where it goes. Anyway, you got 30 days to vacate Riverside townhouses or you're subject to being evicted. All right, you can take her out to the jail. I'll give this to Luke, see if we can get her arraigned. Ms. Zanin, thank you. Ms.
Thank you,
Cousineau,
Judge.
thank you. I don't see you much anymore, but you got a free trip to Centerville out of this. I guess there's nothing else. But I'm sorry we weren't able to do it sooner than this.
That's okay, Judge. Thank you so much.
Thank you.
Melissa.
Still no Miss Walton, Melissa.
She did say she was trying to zoom in, so I'm not sure why she's not showing up then on Zoom. I sent her the Zoom ID too.
I think she's used it for landlord tenant court.
Oh, okay.
All right, this is file 232155FY. People versus Lateria A. Walton. Miss Walton, can you hear me?
Yes,
You're in the bathroom somewhere. Where are you right now?
at my house.
All right. Why aren't you here?
Because my ride ignored me and didn't come.
All right. Well, I could have got you a bus. You're charged with home invasion, second degree, and assault and battery. It's alleged to have occurred in July of last year. You have a jury trial set in front of Judge Pattison for next Tuesday. Your lawyer, Melissa Halleck, is here, and she's been here since 8 o'clock this morning, waiting for you. Did you talk to her before today?
I talked to her at my last court date.
All right. What are we doing here this morning, Melissa?
I did speak with Mr. Marvin with regard to her case this morning. He indicated that it was a different offer than what had previously been offered at her other PCC. That he was not offering a misdemeanor, that with the upcoming trial and now this new assault case, that he would not be, that it would be home basically as charged, that she needs to waive a prelim to preserve some sentencing, possible sentencing negotiations upstairs to avoid possible prison.
All right. So would you like me to simply set up for a preliminary examination for next Tuesday, and you and she can discuss it further?
Yeah, because I do think there's going to be further negotiations with that upcoming trial as well that may change things. I would assume that they're trying to resolve both cases. And I have not been able to convey to Mr. Truckee either the changes in the circumstances of my case, which is he represents her on that jury trial.
All right, I'll set this for preliminary examination December 12th at 1 o'clock. Miss Walton, it's your obligation to be here next Tuesday, December 12th. You can't phone it in. You're going to have to be here live. So if you need a ride, you let me know and I'll get you a bus pass. But this is a felony charge. It's not a traffic ticket. You need to be physically at court. You also have a case next Tuesday. Have you talked to your lawyer, Mr. Truckee?
Yes.
And what Melissa discussed is perhaps they could resolve both cases at once. They're going to bring in 30 or 40 jurors next Wednesday for that trial unless the case is resolved. So your obligation here is to be here next Tuesday, December 12th at 1 o'clock. Tuesday, December 12th, 1 o'clock. Your jury trial is the following day, December 13th. So you need to stay in contact with both of your lawyers. They're working with the prosecutor to see whether they can resolve this. So you're here by Zoom. That's good enough for this circumstance, but you have to be here live next week. Do you understand?
Yeah.
Do you have any questions?
No.
All right, you look quite bored and indifferent to all this.
I'm
These are
not
very-
bored. I'm going through something, actually. Thank you.
All right, well, you're going through something, all right. You have a felony charge pending.
Oh, you're
So
trying to be funny. It's not funny.
no, I don't think it's funny at all.
You smart remarks. You acting like it's funny. It's not funny. Like, yeah, you're a judge. You probably don't go through the stuff that we go through. That's not what I'm going through. That's not the only thing. But okay.
All right, all right. It's not the only thing you're going through, but this is more than an inconvenient nuisance. It's a criminal charge with a serious consequence. So I want you to stay in contact with both of your attorneys and physically be here. If you need a bus pass, you tell me and I'll get you one.
Thank you.
All right. All right. She's going through something. All right. I guess we all are going through something, but we'll deal with this. Good luck trying to shepherd all these two cases together. She's entitled to have a prelim if she wants. She's entitled to have a jury trial if she wants. So thank you, Melissa.
Okay, thank you, Judge.